Mr. Scott.
Good morning, my lady. May we please call Dr. Barry Jones, who can be sworn.
Ask you to put this in your right hand and repeat after me, please. I swear by Almighty God.
I swear by Almighty God
That the evidence I shall give.
that the evidence I shall give
Shall be the truth.
shall be the truth,
The whole truth.
the whole truth,
And nothing but the truth.
and nothing but the truth.
Thank you. Amazing. Thank you.
Good morning, Dr. Jones.
Good morning.
Would you give your full name, please?
Dr. Barry Jones.
And you've been called today to give evidence as the chair of the COVID-19 Airborne Transmission Alliance. You are also the lead for the British Association for Parenteral and Enteral Nutrition, is that correct?
Correct.
Would you give a little bit about your kind of personal background and qualifications, please?
Yes, I am a retired consultant physician and gastroenterologist with over 40 years' experience in the NHS. And as you said, I lead for BAPEN. I'm also a member of the British Society of Gastroenterology, which is one of the core groups of the Alliance.
And you just call it the Alliance there. Is that the way that you would refer to it rather than CATA, which is the way I may normally refer to it?
As you wish.
If I can just summarise the history and composition of the Alliance in the following way. So, formed in August 2020 and was initially constituted as the Aerosol Generating Procedures Alliance.
Correct.
And then in September 2021, it renamed to the COVID Airborne Protection Alliance.
Correct.
And at that time, there were a number of professional groups and unions that were part of CAPA, which represented over 100,000 healthcare workers.
That is correct.
And then at around the time that this inquiry was announced, the name changed from CAPA to CATA, as it currently is. Is that correct?
Yes.
And presently, the Alliance represents over 65,000 healthcare professionals from 12 professional bodies.
And many individuals, yes.
Just going to start with a couple of kind of basic principles that are going to go to the core of your evidence today. But what I am keen to avoid doing is duplicating any of the scientific evidence that we've heard yesterday. So, am I right that you've had a chance to review the report of Professor Beggs?
Indeed I have.
And you listened to the evidence that he gave yesterday?
I did.
In terms of Professor Beggs' evidence in relation to the definition of aerosols, routes of transmission of COVID-19, are there any areas about which you disagree with him?
No.
What about the terminology? You were a clinician, so which camp are you in for the terminology?
It's a very good question. No, we absolutely concur with Professor Beggs' expert opinion, particularly on the definition of aerosols and droplets, which we regard as absolutely critical, indeed the elephant in the room, which has followed us throughout this pandemic. And without it, his whole pack of cards collapsed, which I believe is the expression he used yesterday. So we understand what he means by aerosols. It's what we mean by aerosols. And ballistic droplets are over 100 microns, not over 5. And this has absolutely critical impact upon the way CATA has proceeded throughout the last 4.5 years.
Can I just ask, in terms of the difference between, say, a clinical approach and a physics approach, would you maybe categorise it slightly differently and say that it's not entirely clinicians on one hand, but more a IPC professionals would draw that distinction?
I think it's a very important distinction because there are thousands of healthcare workers, doctors, nurses, dietitians, speech and language therapists, chest physios, and so on, who all agree that disagree with the IPC guidance, and they seem to have a completely different view based on bad science, bad interpretation of the science, which nevertheless is what we had to follow during the pandemic. So it would be quite wrong to say that there's a difference between physicists, engineers, and clinical people, because most of us actually don't agree with the clinicians in the IPC group.
Thank you. If I can just come to some of the Alliance's kind of core contentions so that we can understand those and then see how they applied to the guidance. So if we could please have up on the screen INQ 000273913, it's at page 135. This is the witness statement of you on behalf of the Alliance. And if we can just look at paragraph 415, and it's that third line at the end. one of our strongest criticisms is the fact that government decision-making, especially in the early stages of the pandemic, failed to incorporate well-known sources of expertise, practice and evidence-led decision-making of others, and lived experiences of those affected by the disease. And then if we just go down to paragraph 416, if that could just be highlighted, thank you. And it's the second line up from the bottom. Qatar hopes the inquiry will investigate why and how, in a country of so much expertise in the area, was the pool of expertise determining the protection of our most crucial national asset, healthcare, so limited. Can you explain what professional expertise you thought was missing and where it was missing from?
The IPC cell is comprised of experts, apparently, in infection prevention control. And the clue's in the title, they're supposed to prevent and control infection, and they're supposed to be able to tell us how to do that. But an awful lot of other official bodies, not just Qatar, disagreed with them and made their views known during the pandemic. Right from the very beginning of the pandemic, for example, the environmental modelling group set up by SAGE advised SAGE on the 14th of April 2020 that the pandemic was likely to be transmitted by the aerosol route and that the particle size was 100 between aerosols and droplets, not 5. And that was ignored. Public Health England, the parent body, apparently, or perhaps, of this cell, pushed back a number of times in December 2020 and 21 and said they wanted to broaden the use of respiratory protection and invoke the precautionary principle, and they were ignored somehow.
Can I just ask you, Dr. Jones, just in terms of the expertise, so is it right that actually you believe that those who are making the IPC guidance wasn't sufficiently multidisciplinary? Is that the heart of it?
I think that is absolutely true, and Professor Beggs made that point very strongly yesterday, and we would absolutely concur with him.
And there's a separate point that actually the IPC cell and those within government, as you described, weren't actually listening to those who may have had the expertise or those who were on the ground. Is that a separate point?
I couldn't make that more strongly. It was a theme throughout the pandemic that all of us who tried to push back were rebuffed and, as it were, managed so that we weren't a nuisance. And there was an awful lot of expertise directed at the IPC cell and the bodies associated with them, or perhaps superior to them, none of whom seemed to take responsibility for the actions of the IPC cell.
I'm going to come back to communication and bodies and governance later on. I just at the moment want to focus on core contentions. So I'm then going to move to aerosols and the role that aerosols played. Is it right that the Alliance's initial focus, that can come down now to the screen, thank you, when it was formed in August 2020, was that the official list of designated aerosol generating procedures, I'll call them AGPs for short, fell short because it didn't include all procedures which generate aerosols, and it also, the guidance did not address the natural activities such as coughing, sneezing, even breathing, generate significant aerosols which pose a hazard if they weren't provided sufficient protection.
I think that's a very good summary.
Well, it is yours, Dr. Jones. So.
There we are.
And so, is it the essence that the transmission of SARS-CoV-2, or what I would call COVID-19, occurs importantly via the airborne route, via the inhalation of infectious aerosols released secondary to normal physiological processes, and realistically, that those who were making the IPC guidance didn't take a sufficiently cautious or precautionary approach to the risk of aerosols?
I think it's absolutely true. We don't understand why they did that.
And are you saying that the reason why a precautionary approach should have been taken to whether COVID-19 could be transmitted by aerosols was because at the start of the pandemic, it simply wasn't clear whether COVID-19 could be spread by the aerosol route?
Two answers there. First of all, I don't agree that it wasn't clear, but let's assume that it was unclear to them. That comes under the heading of scientific uncertainty, and the precautionary principle is defined as being should be invoked when there is scientific uncertainty. You fail safe, as it were, and they didn't do that.
And the reason why that mattered is because the wrong PPE, as you say, was being advised, because actually the surgical marks, even fluid-resistant ones, don't prevent the aerosols from reaching the nose and the mouth and therefore initiating the disease, and therefore healthcare workers weren't as protected as they could have been.
This is another consequence of the elephant in the room. Yes.
Can I just check the dates, Dr. Shays? You say you don't agree it wasn't clear it was the aerosol transmission. You said it was the 14th of April when SPI modelling group advised SAGE it was likely to be. What date, roughly, would you say when it became clear that it was aerosol transmission?
It was defined as aerosol transmitted from the very moment it came into the country. It was an airborne, highly consequential infectious disease, as indeed SARS-1 and MERS were and still are. WHO says that no virus known to man has ever been shown to change its mode of transmission, but this one did, under the auspices and direction of the IPC cell.
I will be going through various documentation, Dr. Jones, to allow you the opportunity to say when you think that the evidence was there, but then also, as you said earlier on, even if it wasn't initially there, to those who were in the IPC cell, when you say that actually the evidence was fairly overwhelming and should have been taken into account. So I will take you to that. I just want to deal firstly to the boundary idea, this 5-micron distinction between
Yes.
an aerosol and a droplet. That was the, let's call it the orthodox approach within the IPC community prior to the pandemic. Is that the way that you would describe it? Whether it's right or wrong, that was the view.
That is
was taken.
correct, and it still is.
Yes. And is the basis of that approach was because 5 microns was the upper size limit of what could penetrate down into the deepest part of the lungs.
I think the limit goes up a bit further than that, according to Professor Beggs.
Yes.
But it's roughly that area, yes.
Yes. And so therefore, does it follow that if you take the view that anything under 5 microns is an aerosol and that anything over 5 microns is a droplet and that droplets act ballistically, then that effectively sets you down the path that a droplet behaves ballistically, so you can protect people by wearing a fluid-resistant mask because it captures all droplets and therefore the infection doesn't spread. Is that essentially the logic behind it? Yes, that is
correct.
But if, as it turns out, there are aerosols that are over 5 microns, then effectively the protection isn't there because while you're wearing the fluid-resistant mask, aerosols escape around the side of the mask and then can enter around the side of masks of other people who are wearing those. Is that essentially the reason why, if you have this 5 micron border and you call everything above it a droplet, that actually you then inherently bind yourself into the wrong protection?
Yes, it's why it's not an academic distinction. It's one of extremely important practical distinction. And all pronunciations on droplets by the IPC guidance cell are null and void as a result of Professor Begg's evidence yesterday and our belief.
In terms of the precautionary principle, my lady was saying yesterday she's heard different people address the precautionary principle in a slightly different way. Do you think it necessarily matters whether, when you are looking at creating guidance, you apply the specific precautionary principle or whether you take a precautionary approach to addressing risk?
I think as far as my members are concerned, we wouldn't draw a distinction between the two, but this precautionary principle is actually enshrined in health and safety regulations. So there is a legal aspect to this as well, but we would take a practical precautionary approach, a fail-safe approach, if you like.
And so when you're creating something like IPC guidance, how should that precautionary principle, precautionary approach, how should it be applied? How would you describe it?
Well, if we take the specific example of what happened in mid-March 2020 with the downgrading...
Well, I don't necessarily want to deal with the specifics now.
Okay.
Just in general, when somebody is creating guidance.
Then they should always err on the side of safety and not and listen when they've told that they've got it wrong.
And you were saying that this originates from health and safety legislation, essentially.
The precautionary principle is enshrined in UN documents, WHO documents, SAGE documents, and in health and safety regulations. It's not for interpretation by the chair of the IPC cell, in our opinion, because that's what she did.
Is there a minimum evidential threshold that you think should apply when the science is uncertain, such as in the early stages of a pandemic, before any kind of precautionary principle or the precautionary approach applies?
If you take an academic, an academic evidential threshold, I guess we could probably find one. But in practical terms, a healthcare worker can't apply that at the coalface of looking after a patient. I don't understand how that can be done.
So when you're creating guidance, how do you actually then include that precautionary approach into creating that guidance? What should you be doing? What should you be describing? What should you be considering?
Well, by their own admission, they didn't know as much as they should have done, and therefore they should have said, well, what is the safest approach we can take which will protect the greatest number of healthcare workers and, by inference, their patients and the public as a whole?
So it's if you consider that there could be a risk, then you should take steps to mitigate that risk.
Yes. You know, if you think there's asbestos in the building, you don't think about it, you put on a mask.
And is it also right that actually, simply because you may have identified two risks, that if you're protecting against one, doesn't necessarily mean that you're protecting against the other?
Correct.
And also, is it right that when you are creating guidance, particularly when you're dealing with a novel or a new threat, that it's important that you impose that precautionary approach at an earlier stage?
I can't think of a more important time to do so.
And you also say in your statement that you believe that that should remain in place until such credible scientific evidence exists which shows beyond reasonable doubt that the disease is not transmitted, in this case via the aerosol route. Why is it that you say it should remain in place until it is beyond reasonable doubt?
Because the risk remains until you can be sure that that risk does not pertain. And even the Deputy Chief Medical Officer, Jonathan Van Tam, said in January in an email that it was airborne until proven otherwise.
So it's that certainty that you're looking for when you, at that point in time, you dispense with a precautionary approach?
If you could prove that it was not caused by the airborne route, that's fine. But actually, most of the effort was directed towards trying to find positive evidence of the airborne route whilst not looking for any for the droplet route. And indeed, there wasn't any evidence for the droplet route.
Well, just dealing at the moment still with these principles about how you actually create guidance, talking here about proving evidence certainty, how easy is it to actually design studies about routes of transmission for specific infectious diseases?
Are you asking me here about my opinion on what research should be done during the pandemic?
No, I'm asking you generally, how can you design studies about infectious diseases? Is it an easy thing to do, or do you end up with difficulties about trying to infect people with diseases?
Right, well, in that case, I'll ask you how far you want me to go back, because we can go back to Hippocrates. And I'm not joking. The discussions in medical circles have gone on for millennia about how diseases are transmitted. And nearly always, when new discoveries have come along, they have been ignored. I can give you the Bow Street pump and cholera, for example, in 1854, and John Snow's excellent epidemiological work. It was ignored. It's quite clear that cholera was transmitted through water, not through the air. You say experiments. We have to go on evidence that we have. Particularly in the early stages of a pandemic, you haven't got time to do experiments. You have to look at the evidence you have already and then to use something which a lady mentioned yesterday, which is common sense.
Yes, but also in terms of the scientific discovery, you would still be trying to investigate additional sources of evidence. Is that right?
But we already had the evidence when this virus came. It's the same class of virus as SARS-1 and MERS. They're both airborne. Why should it be any different?
Again, taking a step away from the specifics, and in case there is a future pandemic where actually there may not be that same level of certainty from an existing
Yes.
virus, how easy is it to generate studies about routes of transmission of specific infectious diseases? Is it a very easy thing to do, or is it actually very difficult?
I think in the case of a respiratory pathogen, which SARS-CoV-2 is, one has to assume that it is transmitted by the airborne route, like TB and measles, and like previous coronavirus epidemics. I'm not an expert in designing studies on aerosol or on infectivity, but so I'm not sure that I can answer your question fully.
That's okay. I'm going to move on to applying precautionary approach to the evidence. If I can just take you to document INQ 000273913 against your statements, page 30, paragraph 99. You say health and safety legal principles critical to the protection of the most vital asset during a pandemic, in brackets healthcare professionals, were simply abandoned in favour of infection prevention and control approaches. Please can you explain what you mean by that?
The infection prevention control specialists who dictated guidance during the pandemic made statements which were not based on evidence. One could even call them dishonest statements. Health and safety incorporates the precautionary principle to protect workers, and in this case, healthcare workers. And although the IPC guidance says that their guidance should be interpreted in the light of health and safety principles, they then ignored them because they did not take the precautionary principle in the face of scientific uncertainty, which they professed all the time. And in fact, there was certainty, and they should have noticed it.
So, in terms of the health and safety principles there, that's for the read across for precautionary principle, is that right?
Yes.
And you said there about you used the word dishonest. Can you please be very specific about what you mean, or any specific statements that you're saying may be dishonest?
It's not just our IPC cell, but the World Health Organization, which initially categorized this virus as airborne, then put out adverts, if you like, Twitter and other media, saying COVID is not airborne. We have similar statements time and time again in the IPC guidance. We had a letter from Professor Powis, Doyle and McEwen to all healthcare workers saying COVID is not airborne, it's droplet and surgical masks are fine. All this was not based on any evidence whatsoever, and yet they kept telling us in our responses to our many letters, we are following the science. This is the result of the latest scientific review. That is untrue.
Do you believe that at the start of the pandemic that there was any scope for there to be differing opinions on the scientific principles that apply to the routes of transmission?
Well, there clearly were differences. We don't understand why, because as I've just explained, they weren't based on the science, and yet the government said that it was following the science. But instead, it followed bad science, given to them by those who should have known better.
But are you saying that there may have been differing views on the science, even if you don't necessarily agree with them? But are you saying that the people making the guidance were not following what they believed was a proper scientific view?
Well, they seemed, as Professor Noakes said in her Module 2 evidence, and Professor Beggs yesterday, there seemed to be a desire on the part of those putting together the guidance to seek very, very hard for high-level evidence to prove that the airborne route was the dominant one, whilst having no evidence whatsoever to justify the droplet one, then or since. And that disparity is completely wrong. It's not scientific. It's a reflection of a culture.
Because I just want to be very clear about what criticisms that you're raising. So you're criticising the scientific approach rather than the fact that people may have been following a scientific approach.
Yes.
To what extent would you say, or accept or not accept, that if the WHO said it's, I appreciate you say it changed its mind, but is it fair for experts in this country to say, well, if this is what the World Health Organization says, that ought to be based on the science and therefore we ought to follow it?
Well, the WHO didn't offer any science either. And I see no reason why the excellent scientific community in this country has to automatically follow something so blatantly unscientific, no matter where it comes from.
Thank you.
Thank you. That can now come down off the screen. Going to come back to a point that the lady raised about at what point in time, and I think it's going to be very clear from the evidence that you've already given, from what point in time you believe the precautionary approach or the precautionary principle should have applied to the IPC guidance.
March the 13th, 2020.
And why wouldn't it have applied any earlier than that?
Because up until that moment, this infection was classified as airborne, and airborne precautions were being given to healthcare workers to protect themselves at work, and suddenly they weren't.
Well, can I just explore that a little bit? Because you're referring there to HCID status, is that right?
Not directly, and I shouldn't have to, but I understand your question. So yes.
Well, could you please explain what it is that you mean in terms of why before that date you believe the precaution principle didn't need to apply?
Because as the virus came into the country, it was classified by JCVI as a highly consequential infectious disease, which, as you know, is very strictly defined. And the criteria upon which HCID status is founded were rapidly exceeded as this virus took off and exceeded the capacity of HCID beds and then isolation, the 500 isolation beds in the UK. But at the same time as it was given HCID status, because it was a respiratory pathogen, it was given airborne status as well. The two are not necessarily inextricably entwined. In other words, you can have a non-HCID, which is airborne. You can have an HCID that's not airborne. But it just so happened that at the same time as the downgrading from the HCID, as you call it, status occurred, the type of personal protective equipment, particularly respiratory protective equipment, was also downgraded from what was perceived as safe and the best possible protection for staff to something that clearly wasn't, and no explanation was given.
If I could just make sure I'm fully understanding this. So in early January, COVID-19 was designated as a HCID, the way I call it, yes. And actually, would you agree that that is probably a good idea? Sorry, that is an effective use of a precautionary approach because we weren't entirely sure about levels of mortality and all the various elements that go into make something an HCID. Is that right?
It was entirely appropriate because SARS-1 and MERS, as I've already said, are categorised as airborne HCIDs to this day.
But there are only two categories of HCID. There's airborne and contact, isn't there?
Correct.
So you couldn't, for example, have a droplet HCID.
Well, you probably could if it was the IPC cell that was in charge, yes.
But in terms of the designation, it's either contact or it's airborne. So simply because something is designated as an airborne HCID, it doesn't necessarily mean that that is a definition of it transmitting by the aerosol route as opposed to the droplet route. Is that right?
Well, if it's an airborne HCID, it's an airborne HCID, and you have to deploy the adequate protection for what is a far more serious and efficient method of transmission than droplets.
Yes. Because something has been designated as an airborne HCID, then a standard set of PPE, which includes FFP3 masks, that then applies, doesn't it?
Yes.
And that would always have applied for as long as any virus is designated as an airborne HCID.
Correct.
So, for example, SARS is still designated as an HCID.
And could I just add that the World Health Organization says that no virus known to man has ever been known to change its route of transmission. So why did this one?
Yes, but if there is no droplet HCID, then how does it necessarily follow that because you have downgraded something from an airborne HCID, that you say that it necessarily follows that they were changing the route of transmission of that virus?
I don't know why they changed the route of transmission. That's a question we need to answer.
So you're not saying that it necessarily was changed, but the fact that the downgrading changed from airborne and then the droplet protection came in is what you're saying is the reason why you believe that there was a change in the route of transmission?
Well, it did. Well, they said it's droplet transmitted. The first edition of or iteration of the guidance that came out after the downgrading from HCID status said it's droplet transmitted except for aerosol generating procedures, and therefore only protections which will protect against droplets will be used for all non-AGP situations, which is actually the majority of healthcare provided in a hospital.
If I can look, please, at its notes of a meeting of NervTag on the 3rd of February 2020. And this is INQ 000119615. And if we can go, please, to page 4. And paragraphs 3.10 and 3.11. So we have there, so JVT, there's Jonathan Van Tam, is that right? Mm-hmm. Asked if it's the committee's view, and so committee there is NervTag, that for this novel coronavirus, we do not understand the modes of transmission of this virus, and we do not understand the relative contribution of fine particles, aka droplet nuclei, large droplets, and contact transmission. At 3.11, members commented that yes, NervTag do not have a full understanding of the modes of transmission, and they're making assumptions based on other respiratory pathogens. But it's reasonable for us to infer the nature of transmission of this virus. If that is the assessment of a group such as NervTag, would you expect to see that uncertainty presented in any guidance that applies?
Well, first of all, I don't understand the conclusion of 3.11, because if you actually look at the modes of transmission of similar things, you wouldn't end up hand washing. So that, I don't understand that at all. Sorry, the other question was, sorry.
That if a group such as NervTag are saying that they do not understand the mode of transmission or do not fully understand the mode of transmission because it's put both ways, would you expect that uncertainty to be identified in any guidance that follows?
Yes.
Can you remind me the date of the meeting?
This is the 3rd of February.
3rd of
So this is still within the HCID period.
Yes.
Thank you.
But is it right that when you are responding to a virus that has the potential to be a pandemic, which I think had already been identified by the 3rd of February, that you may wish to start to plan for what your IPC guidance may be if you take the view that it is no longer to be classified as an HCID?
Well, indeed, you're correct. That planning had been taking place, but there was only one plan in town, and that was the pandemic influenza plan, which had been formulated in the previous decade, and which they decided to implement come what may, which may have been convenient because they didn't have enough PPE anyway for an airborne route. As we've already seen in Module 1, of course, with regard to preparedness.
Because you then say in your statement that the precautionary principle was removed from IPC guidance in mid-March 2020 without any such evidence. Is that the discussion we were just having in relation to the declassification as HCID?
They occurred at the same time, which I'm sure was no coincidence.
Well, the IPC guidance came in on the 16th of March, because when you've declassified as an HCID, you then have to have a set of guidance about the IPC and the protection needs to be put in place. Is that right?
They'd already decided that some weeks beforehand, according to the evidence.
If we can
just look at... It wasn't decided afterwards.
If we can just look at, please, at that guidance, and that's INQ 000325350. So we can see there that this is, at the top, version 1.0 of the IPC guidance.
Yes.
And that's adapted from the pandemic influenza guidance.
Correct.
If we can go to page 7, please, paragraph 2.1. And if we can take that top paragraph.
Yes.
And we can see it set out there. This is under the heading of routes of transmission. And the opening line is it's based on the reasonable assumption that the transmission characteristics of COVID-19 are similar to those of the 2003 SARS-CoV outbreak. You don't disagree with that line, I presume?
Absolutely, I agree with that.
And
But not with the rest.
so your disagreement there is the transmission is thought to occur mainly through respiratory droplets.
Well, SARS-1 is transmitted by the airborne route. There are lots of papers to show that, and it's still designated as an airborne HCID. So why would I believe that it's transmitted by droplets? They never presented any evidence to that effect whatsoever.
If I could just take to the line in the middle. The one.
Sorry, if I could just add to that. Of course, it's respiratory droplets generated by coughing and sneezing. Here we come back to the elephant in the room and the size of aerosols versus droplets, as described by Professor Beggs yesterday. All of the droplets, so-called, generated by coughing and sneezing that they're referring to are, in fact, aerosols. So that statement is incorrect.
And so that's where you disagree with this.
Absolutely.
Because at the bottom line, bottom 4 lines, during AGPs, there's an increased risk of aerosol spread. So you would agree that they recognise the concept of aerosols.
Yes.
But what you're saying is that actually it was applied in too narrow a set of circumstances and it should have applied generally.
It's an example of terribly badly applied science.
And if we can go, please, to page 12. And we have at the bottom there routes of transmission. Thank you.
Yeah.
And again, as that bottom paragraph, interrupting transmission of COVID-19 requires both droplet and contact precautions. And then it's only if an AGP is being undertaken that airborne precautions are required.
Yes, and in the paragraph you'll notice above, it's less than 5 microns for aerosol. So again, the elephant in the room.
So this is, as you say, the fundamental flaw that then applies throughout all the IPC guides.
It's completely wrong. All of the guidance was based on this false assumption, which they should have known about. They're supposed to be the experts in infection.
So you've made it clear that you believe that a precautionary approach should have applied from the outset. You've also made it clear that you thought that the science was sufficiently clear from the outset of the pandemic that aerosol should have been protected against. Do you say that there came a point in 2020 when effectively the scientific base became pretty much unanswerable, that aerosols was a viable route of transmission or the primary route of transmission?
Yes, I can give an answer to that. I can answer partly from Professor Beggs's evidence yesterday. Of course, he said that by September 2020 there was sufficient evidence. But I would actually put it earlier than that, because Professor Noakes, who gave evidence to this inquiry in Module 2, Professor Andrew Curran from HSE, joint chairs of the newly formed EMG committee, a subsidiary of SAGE, within a week have prepared a document saying the disease was airborne and aerosols went up to 100 microns, and they presented that to SAGE a week later, a week after the formation of that group, on the 14th of April 2020. But no one took any notice, and there were several more recommendations from that group. And curiously, SAGE reverted to the 5 micron in their June report. So we don't know what was going on there. But I would argue that left and right hands didn't quite seem to know what was going on at the time. But to us, it was very clear that the evidence was already there, very, very early on, only weeks after the downgrading from HCID status and downgrading from respiratory protection to droplet protection. I hope that answers your question.
Yes, it does. If I can take you then to some minutes of or some notes of the meeting of the IPC cell on the 22nd of December. If I can take you to INQ 000 398244. Thank you. And just because it will become relevant later on, if I could take you, please, your attention just in the attendance list. At the end of the second line, we have Ellery Davis and Public Health Wales, and then on the fourth line, Colin Brown, PHE. So those initials will be ED and CB, just because they'll become relevant later on. If we can just go over, please, to page 2. And down at the bottom we have LI, which I believe is Laura Imrie, where this at the time is there is a discussion about whether the new variant, I believe at that time, was quite prevalent in December 2020. And there's a note there about wary of recommending FFP3 masks and should look for the evidence first. Now, I know that you believe that the evidence was already there, but then we have a note from CB talking about difficulty that the evidence is generated. If we can just go over the page, please.
Oh, yeah, here we go.
So that you have the second entry, which says minimal evidence of patient-to-staff transmission. We should not need to further recommend FFP3 masks. If we can just avoid zooming in just for a minute, please. Sorry.
Sorry, that point, I mean, that was incorrect. There's very good evidence that healthcare workers were becoming extremely ill and dying in Italy and in China and in this country by then.
But it's in between the two NRs, kind of the last two. You have an entry as CB. That's the reason why I pointed to CB.
Yes.
Our understanding of aerosol transmission has changed. A precautionary approach to move to FFP3 masks whilst we are awaiting evidence should be advised. So this is a note of a comment from a member of Public Health England. The IPC cell didn't actually, at that point in time, change the guidance and make a precautionary move to FFP3 masks. What was your understanding of the way that the IPC cell operated? And when I say that, as an outsider at the time, did you have any idea of how the IPC cell operated or what it was doing or what it was discussing?
That's an important question because we knew what was coming out of the IPC cell, but I had no idea where it was coming from, who it was coming from, because they never, ever published any minutes. We managed to obtain some with great difficulty through freedom of information, and of course we've seen some disclosed documents. And we didn't know at the time who was on that, in that cell. We knew that Lisa Ritchie was the initial chair and later Dr. Davis, I think. But subsequently, we have learned that the composition of that cell was predominantly from NHS England. I think there were 28 people altogether, and most of them, there were 3 representatives from Public Health England, and I'm not sure they had voting rights. And the terms of reference, which were eventually only in draft in 2020 and eventually agreed in 2021, said that the chair had the final decision when there was disagreement. And we see in the minutes several times that consensus has been reached.
If I could just ask you to pause there, because I think this
because
is the minute where we're talking.
She overruled him.
Well,
he ignored that comment. That's the point I'm trying to make.
If I could just scroll down just to actually evidence that point that you're making. So if we scroll down to, there's lengthy discussions there, but fourth line up from the bottom, where ED, I think we just go a little bit further down on my screen. Thank you. ED, so that was looking for Public Health Wales that we were looking at earlier on, second line up from the bottom of the screen at the moment. There will be pressure from organisations and bodies for more precautionary measures. The confidence of staff in high-intensity units is being lost. That's correct, that in December 2020, the confidence of staff in high-intensity units is being lost.
It's absolutely correct.
And then the comment is, if there is a high-risk pathway, we should take precautionary measures.
Correct.
And then if we just go over the page, I think this is the point you were making about consensus, that it's that note there, LR, we appear to have consensus. And then that's set out. You weren't involved in those meetings, so I'm not going to ask you about how that comment came to be made. But was this what you were talking about, where you were saying consensus was noted, but actually you don't believe it was there.
It's not the only example. It occurred a year later as well, when Colin Brown also presented a paper a proper paper from PHE saying they ought to relax respiratory protection beyond AGPs and the precautionary principles should be invoked. And we don't understand how this cell could actually overrule the parent body, Public Health England, UK HSA as it's become. It's bizarre. It's tail wagging dog.
Thank you. That can come down now. If I can, I think you've been very clear, Dr. Jones, in your evidence about when you believe that the science was there, when you believe that the changes. If I can just take you to, it's the technical report that was generated by the chief medical officers following the pandemic, and it was intended to give advice to future CMOs.
Ah, yes.
If I can show you, it's INQ, it's 203933. It was published the 1st of December 2022. If I can take you to page 48. And this is, actually, if we just go back a page, because then we could show the heading. So this is what were the important routes of transmission. This is section 8 of chapter 1. And then sets out some analysis. But if we just go over the page, and it's those top 2 paragraphs, please. Given the challenges inherent in attempting to determine the relative impacts of different routes of transmission, it was important to retain an open mind as understanding evolved over the course of the pandemic. Again, is that precisely what you believe didn't happen but should have happened?
It most definitely is. And of course, this was written partly by Professor Kath Noakes, we've already heard evidence that she was ignored.
Thank you. I want to ask you now about lessons learned and learnings that were arising from masks, protection, elements such as that. Again, that document come down now, please. Thank you. In terms of the masks that you believe should have been advised, so you're talking about FFP3 masks, do you believe that they were the only masks that should have been applied, or do you think that there are different approaches that could have been or should have been taken?
Well, if I may be so bold as to correct you, that masks are not the only mitigation for an airborne transmitted pathogen. Ventilation is incredibly important, and that was ignored and could have been mentioned way back in March 2020, but wasn't until November 2020 by Cabinet Office. Masks, or respirators to give them their correct term, protective ones like FFP3s, maybe FFP2s, and N95s across the water in North America. Those are the ones which provide the greatest protection, but they're not, again, not the only form of protection. The power-assisted personal respirator hoods provide a very, very useful alternative, and I'd quite like to explore that later if we may. So there's not just FFP3 masks we're talking about here. And I'm very pleased to see that this inquiry building has lots of HEPA filters around, as well as mouse poison in the room where I was waiting.
In terms of the masks, we might as well deal with them now that you've raised them, Dr. Jones. What do you consider as a representative of somebody, representative of many people who were actually healthcare workers on the ground, to use that phrase? What do you consider were the benefit of using personal hoods, powered hoods, as opposed to just FFP3 masks?
They provide a number of advantages. Although they look quite scary and a bit Star Wars, they provide clear visor, which patients can see through. They can see for communication purposes, very important for speech and language therapists. They protect the eyes. They stop droplets, but above all, they stop airborne particles. They are reusable. They don't have to be disposed of after a few minutes of use. and after a couple of years they pay for themselves. And the best example of their use comes from Southampton University hospitals. And I can expand on that if you like.
Please do. Yes, please do.
Right. Professor Paul Elkington, who was awarded an MBE for this work, by the way, worked with his colleagues in Southampton and with the president of BAPE, my president of BAPE, Ben Trevor Smith, to design, manufacture and distribute what were called Perso hoods. They did this at pace and at scale in the early months of the pandemic, and they distributed them not only to intensive care staff, but all staff in the hospital, whether clinical or support workers, so porters, cleaners, and so on. And they heard that they had feedback that these were vastly preferable to wearing very horrible FFP3 masks for long periods of time, and they were given a mask for the duration of the pandemic. They were in the top 10% of trusts in this country for low nosocomial infection rates and staff absenteeism due to COVID. They worked.
Do they require fit
practical.
testing?
They don't require fit testing either. And if I can just add that Paul Elkington and his colleagues approached not only the president of the Royal College of Physicians, Professor Goddard, you will hear from later, but Sir Stephen Powis, who was involved in the communications in April 2020. And Professor Elkington offered not only this expertise, but the manufacturing capacity of Jaguar Land Rover, which were prepared to manufacture these at pace and scale. And we never heard any more about it.
In terms of lessons learned, you believe that actually consideration should be given to using these kind of powered respirator hoods?
Well, there's no doubt from listening to those who've been unfortunate enough to have to wear FFP3 masks for a long period of time, and I've worn one for 5 or 6 hours. It's not particularly pleasant. But the side effects quoted, apart from being uncomfortable, side effects like acne really aren't life-threatening. But there is an alternative, and the power respirator hoods, I think, need exploring. And there are all sorts, as I've explained, there are all sorts of advantages. And they do get around the enormous problem of 20%, maybe 40% fit test failure, particularly for those from BAME ethnic backgrounds, with beards, turbans, and faces that just don't fit. And bearing in mind that over 50% of the NHS workforce is female, and masks are only, FFP3 masks are designed on mannequins based on the male face, it's hardly surprising that there are a lot of fit test failures, but hoods get round that problem, which is a serious logistic problem, in fairness.
Just the final area in relation to IPC aerosol guidance before I move on to something slightly different. There's been a lot of discussion in your statement in relation to designating certain procedures as AGPs. If there had been sufficient aerosol protection, as you contend that there should have been at an early stage because it was sufficiently clear, would there have been any issue in relation to what was an AGP, what wasn't an AGP, or actually would the protection have already been in place, whatever happened?
You're absolutely right. And indeed, English manual for IPC now states that when you go into the room of a patient with suspected or confirmed COVID or a similar respiratory pathogen, you should don respiratory protective equipment. So why would you need to put it on for an AGP? AGP list would indeed be redundant, but it was never fit for purpose in the first place.
Well, I just want to deal with the benefit of having that protection in place. So were any of the AGPs that were actually on the AGP list potentially life-saving or time-critical procedures?
Yes.
And so if there had been general wearing of FFP3s, would that have had the added benefit that you were not reducing, that you would have reduced the time it takes to don the IPC in order to carry out an AGP?
I would say that if we're talking about, are we talking about CPR now, cardiopulmonary resuscitation?
Well, anything that would be time critical or potentially.
Okay, well, if we use that as an example, we had the absurd situation of paramedics arriving at a patient who died in the street, and having to put on full PPE with gowns and gloves and so on. But basically what they needed to put on was an FFP3 and a pair of goggles. And that doesn't take very long and shouldn't have delayed the administration of the treatments necessary, chest compression, etc. It would have facilitated a much speedier response. And indeed, at one time, they even had to wait for managers to arrive to do a risk assessment, which is absurd.
Just moving on to a different topic, and this is about communication consultation with healthcare workers of the IPC guidance. We were asking earlier on about whether the IPC guidance should reflect uncertainty in the evidence. Would healthcare workers actually have been able to accept and understand that there wasn't necessarily scientific certainty in the routes of transmission, and that they would have just adapted and dealt with the guidance that they were given?
Healthcare workers, by and large, are both intelligent and caring people, and their purpose is to look after patients. That's why we become healthcare workers. If, on March the 13th, 2020, the powers that be that told us it was only droplet and surgical masks were fine and will protect you perfectly well against an airborne thing had actually said, look, it's tough. There's a world shortage of PPE. We would have understood. We knew there was a world shortage. It's not something which we were ignorant of. We would have understood that. And if they said, well, because it's airborne, we can't give you the best possible mask, but we can ask you to open the windows and the rest of the population to take precautions, recognizing that it's airborne and not just droplet. And when we have enough masks, we will provide them to you as soon as possible, and we're working day and night to get them for you, sort of thing. Now, we know that by the autumn of 2020, they did have enough masks of FFP3 type. CATA and its predecessors wrote repeatedly to Prime Minister, Secretaries of State, First Ministers, so on, Public Health England, NHS England, Chief Medical Officers, to try and get a change. And we even gave them the option of saving face with each new variant that came along, which was more transmissible. And each time they came back and said, well, the IPC cell said, we've reviewed the evidence and the virus hasn't changed its mode of transmission, so we don't need to change the protection. Well, it hadn't changed its mode of transmission, of course, but as they got it wrong in the first place, that was a problem. That's the elephant in the room again.
You'd said earlier on in your evidence that you felt that you'd been managed out of raising those concerns.
Yes.
Do you think that that meant that the voices of those on the ground effectively weren't being heard by the IPC cell or those creating the guidance?
Well, they weren't. If we just look at CPR, the Resuscitation Council UK and the Royal College of Physicians, who should surely be the arbiters of such guidance, were completely ignored. And the cell continued to say that CPR is not an AGP. It causes no more trouble compressing a chest than someone coughing. Well, that's true too, but they completely missed the point that coughing generates vast amounts of aerosol. There seemed no way in which healthcare workers, which I was associated with during this pandemic, could actually get to these people and get a sensible response. They never really ever responded to our scientific criticisms. They just came back and said, read the guidance, it's based on the latest science, which it wasn't, and that's it. We were managed. We were pushed away.
Do you think if there had been some clarification or if there had been some indication that actually there wasn't complete certainty in the evidential picture regarding aerosols and that had been transmitted in the guidance, do you think that that would have generally helped healthcare workers feel safer?
Well, we would have understood it. And I don't think it would have resulted in the loss of trust in guidance and the demoralisation of the healthcare force. And this is put very clearly by Dame Donna Kinnear of the RCN in a joint letter with them to the Prime Minister, that there was unequivocal demoralisation and loss of trust in the guidance.
Just a small topic was, you raise in your statement about an inability for there to be local risk assessments to be carried out. Can you please expand upon what you mean about how it's not possible to carry out local risk assessments within an IPC framework?
Yes, I'd be glad to. First of all, there was no guidance ever given by the IPC cell on how to do a risk assessment, certainly not a local one, and nor from HSE either. We asked them and they were silent on the subject. So they gave us no advice on how to do a risk assessment. If you're going to do a risk assessment, you have to know what the risk is. The risk was defined as droplet, for which only surgical masks are used. So if you do a local risk assessment, you say, well, actually, I'm going to be within 1 metre of this patient. And by the way, most healthcare occurs within 1 metre of a patient. Of course, no healthcare has an arm longer than 1 metre. You're in the danger zone there, and you might reasonably say, that sounds like high risk. I'd like to use higher grade protection. But the guidance says, no, you can't. It doesn't just say, no, you can't. If you look at the June 21, it actually says FRSMs must be worn for close range care within 2 metres. So where is the flexibility for local risk assessment when you've got guidelines like that, which are going to be read by managers and IPC leads in each trust? And finally, the proof of the pudding is in when people actually tried to do local risk assessments. If I can give you one very good example at least, we have in this room Dr. Natalie McDermott, PhD, who tried to do this. Now, she was one of the most experienced infectious diseases doctors in this country, with experience of managing epidemics in Africa and Asia. At the beginning of the pandemic, she went to her trust leads and said, this is an airborne pandemic. I know it is because I've worked with them. And I want to have proper protection. And they said, no, you can't have it. You've got to use an FFP3 mask. She tried everything she could, but she still had to use an FFP mask when she was looking after her patients with COVID. And it wasn't if she got COVID, it was when. And she did. And she's now in a wheelchair. Terrible consequences as a result of a failed local risk assessment. We have another example from one of our members, Gillian Higgins, who's a...
If I could just stop you there, Dr. Jones.
Yes,
There's one thing that you just said. You said you've got to use an FFP3. I presume you meant to say an FRS.
I'm sorry, yes, I beg your pardon, yes.
Thank you.
Yes.
My lady, I was going to move on to a different topic. I wonder if that might be a suitable time for a break. I know it's I appreciate it's a fraction early. I'm content to move on and carry on with this next topic, my lady, if you prefer.
I detect a degree of encouragement there, Mr. Scott. Very well, I should return at 20 past.
All right.
Sorry if we're a little late back with some urgent administration we had to attend to. Mr. Scott.
Thank you, Dr. Jones. Just a couple of points I'd just like to clarify that are arising from your evidence earlier on. You talked about Lisa Ritchie, and you've been referring to, I think the way you've been phrasing it is her decision-making. It's right, isn't it, that Lisa Ritchie was, for a period of time, the head of the IPC cell. But this advice, in relation to guidance, was advice coming from the IPC cell? That's right, isn't it?
Well, as I explained earlier, if you put in guidance the word must, it ceases to be guidance.
Yes,
and it is interpreted by those, not always at the coalface, IPC leads and managers, as being mandatory.
Yes, but they are the ones
guidance
who are...
should be guidance, not tramlines.
Yes, but the IPC cell was providing advice for the guidance. They weren't the ones who were deciding specifically what the wording of that guidance should be.
Are you telling me that for a fact, or are you asking me to comment?
I'm asking you to comment on that.
I don't agree. they were supposed to be in an advisory capacity. And their findings, their advice was published by PHE, which took no responsibility for them. It seemed to us that the guidance came directly from the IPC cell, and it wasn't advisory to another body which would then implement it. It should have been. It should have gone up through Public Health England, UKHSA, NHS England, to SAGE, chaired by Chris Whitty, co-chair. But it doesn't seem to have happened. It just seems to have been signed off somewhere along the line by somebody. We're still not quite sure whom. We're not quite sure who was in charge, if I could put it that way.
Precisely. It's the lack of certainty about who was taking the decisions rather than necessarily stating that the IPC cell took the decisions. Would you agree with that?
I understand your distinction, yes.
And also, in terms of Dr. Ritchie was the chair for a period. She was part of a cell that took decisions by consensus. So they're not her individual conclusions that she reached. These are the conclusions of the cell. Would you accept that?
No. I don't agree that it was consensus. I agree. I think that she seemed to have taken an arbitrary view and rejected views of a superior body, Public Health England, as described before the break. I'm not quite sure how that can happen.
Yes, but you weren't part of the cell, therefore you're not certain precisely how conclusions were reached. Is that fair?
Well, none of us can be except by reading the minutes, which you showed me earlier, and one can only interpret from the minutes that that was the case.
One other point I want to ask about the scientific basis and the approach to aerosols. It is not simply the United Kingdom who at the start of the pandemic believed that there was not the primary spread of COVID-19 by aerosol route. Is that right? There were other global organisations in other countries also took that view. Is that right?
Correct.
My lady, it may be better to deal with those points with other witnesses rather than to Dr. Jones.
Thank you. They included the National Centre of Infectious Diseases in the United States, didn't they?
Indeed, their views changed a little bit, but they came out very early, as far as I understand it, in favour of airborne transmission and proper respiratory protective equipment, and that situation prevails to the present day.
Just returning then to the idea of local risk assessments. NHS England have asked for the question to be asked about whether, if hospitals couldn't decrease the risks based on the hierarchy of controls at any stage during the pandemic, were they not required to risk assess the level of PPE required for their staff in accordance with their health and safety duties?
So I'm not sure the question is exactly.
Well,
Are you asking me about the hierarchy of controls or about risk assessment?
Well, I think it appears to be that if hospitals had to risk assess the level of PPE for themselves.
Yes, well, that seems to be an abrogation of the responsibility of those purporting to give guidance. I mean, you can't say you've got to do this and then transfer the responsibility to local people. And as I've already explained, can't do a local risk assessment because the guidance doesn't tell you how to.
And what would you also say to the suggestion that local trusts, hospitals, organisations, boards, HSCTs could choose to locally designate a procedure as an AGP?
They could choose, sorry, I missed the last bit.
They could choose to locally designate a procedure as an AGP. What do you say to that proposition?
I've never heard of that.
Would you think it was something that would be possible for local bodies to do given the national guidance?
Not if the guidance says must, no. And as I've said already, that's what managers look at. You can't go to your manager and say, can I have a secure supply of FFP3 for all the people who are looking after these patients doing this procedure, if the guidance says the opposite.
Because if you have IPC guidance, which is setting out standards, is it incumbent upon professional healthcare workers to follow that guidance?
Professional healthcare workers and their representative bodies took the view that they had a duty of care to their members and opposed the guidance and put out their own guidelines, for example, the Royal College of Speech and Language Therapy and my own organisation, BayPen. But when our members took those to their trusts and those in authority in the trusts, they were often rebuffed And it was the guidance which was produced by professional bodies was ignored in favour of the IPC guidance, because that seemed to have the imprimatur of government.
In terms of the wearing of masks, and particularly FFP3 masks, do you think that that would have had a considerable impact on staff if they've had to wear FFP3 the entire time?
They wouldn't have liked it at all.
Do you think...
But then staff didn't like getting COVID either.
Which do you think was more important to staff to protect against?
Well, if it was me, I'd want to wear a mask because I don't like the idea of COVID. And there's at least one person in this room who's had it and will have consequences for the rest of her life. And if you ask her, she will say, I would rather prefer to wear a mask.
And do you think that the fact that there was a possibility that healthcare workers may have caught COVID-19 outside of their professional setting has any relevance whatsoever to whether they should have got less protection from COVID-19 in their professional setting?
That's a good question. Perhaps I could refer to the study from Ferris et al. From Cambridge.
Well, just in terms of referring to the study, I think it's more a matter of principle about whether you do think that there is any relevance to what might happen outside in terms of the level of protection that should be offered to healthcare
I don't think you need
workers.
to pursue that, Mrs. Scott. I don't think there's any relevance. So,
I was just going to say that,
Thank you, my lady.
that community prevalence obviously is reflected in hospital prevalence, but we know that healthcare workers are at much greater risk than in the community.
And then just in terms of any potential recommendations that should be made, I think you were critical of the lack of transparency that there was from the IPC cell as a whole and the decisions that they reached. Do you consider that in the event that there is a body in the future pandemic like the IPC cell, that the minutes of their discussions should be published?
Yes, I thought that was a standing regulation in government. Indeed, the King's speech mentioned the duty of candour, so I would expect that to happen, yes.
My lady, I have no further questions.
thank you very much, Mr. Scott. Dr. Jones, there's some questions from Ms. Mitchell, who is almost directly opposite you. So if I sit back a bit.
Dr. Jones, I appear on behalf of the Scottish COVID bereaved, as instructed by Amar Anwar and Company, and I'd like to ask you a couple of questions. I wonder if we can have before us INQ 000300310. This is an email chain in which you have emailed the AGP panel, and there are a number of emails, but I would just like to deal with the last one of the 22nd of December. It's fair to say in this email chain you have been expressing in terms increased frustration at the fact that the output from the panel in terms of advice or guidance has not been forthcoming. And your email, the top document, if we can have that up, please, of 22nd December 2020.
I've got it up.
Oh, thank you. It's just arrived on our screen. Thank you. This email expresses your continuing concern about the fact that there were delays. And I wonder if I can take you to the bottom of, sorry, halfway down that letter, where it says that your group has been astonished and dismayed at the slowness of the AGP panel pressing need for revised advice, and you've reminded them of the number of people in hospital and also the number of healthcare workers. You've posed a question at the end of that letter, and the question is this. In the context of the fact that you were given assurances that the minutes of meetings would be published, which you've just spoken about, you also say, why has it taken so long for any output from this panel when other scientific groups seem to be able to respond to the changing situation so much quicker? The failure to reflect the urgency of the matter may be reflected in greater mortality and morbidity, which could have been avoided by a more expeditious response. And my question from you in that regard is, did you ever find out what the cause was of the delay from the output from the AGP panel?
This is distinct from the UK IPC cell, just to be clear. And this panel was set up in response to Baypen. I signed the letter to Chris Whitty and to Ruth May, and this was set up at the beginning of May 2020. By September, we'd not heard from them, and eventually I got a message from one of their officials saying they'd lost our letter. And then we got one later saying that they were just getting to the final stages and they will publish in about a month's time. And I got very exasperated before Christmas and wrote this email. As it happens, the question I posed at the end about greater mortality and morbidity, which could have been avoided, it turns out that it wouldn't have been avoided because this panel found absolutely no reason to change the list whatsoever, and I can expand on that if you wish.
Well, no, I think the Chair already may have enough in that regard, and she's nodding her assent to that matter. So there was this delay, and still to this day, this delay remains, at least in your view, unexplained.
I think it's appalling. The rest of us were working at pace to get things done. It took 7 months at the height of the pandemic as the second wave hit. We got the message, we eventually received this report, not in the first week of January when I was promised it by the chair of this panel on the 23rd of December, the day after this email, but in the second week of January. So 7 months, which I think is appalling.
I wonder if I might briefly then move on to another document and ask you to comment on it. That is inquiry number 000118447. This is a response letter from one which you and other colleagues drafted by the chair, Sarah Newton, of the Health and Safety Executive. And this document indicates, if I could guide you down, please, to paragraph 3, that says all employers, including those in the NHS, are expected to assess the risks to their workers created by their work activity and to implement appropriate measures to control these risks. In making the assessment, the employers are expected to use up-to-date and relevant guidance. And then later in that letter, just at the bottom of the page, it says we will not be undertaking a review of this guidance as it's already been done, and lists the various bodies that has been done. Can I ask you, did this letter satisfy you that the appropriate enforcement action had been taken by HSE? And if not, why not?
First question, absolutely not. All the correspondence we had from HSE made it clear that as long as trusts, hospitals were following, they called it Public Health England guidance, that was fine by them. So if they were using surgical masks and off sick, that was fine. It didn't matter that they were wrong masks. And we've regarded the response of the Health and Safety Executive as entirely unsatisfactory throughout the whole pandemic. There may be some good reasons for that. But they didn't have to take this view. They could have said, yes, we do have a regulatory responsibility here, and we should discharge it and make sure that others do too. And as far as we understand it in Qatar, the legal aspects of their responsibility and those applying to employers were not suspended by the emergency legislation during COVID. So why were they not continued?
My lady, Dr. Jones, I'm obliged. My lady, I have a third question, but I think I'm out of time, so I shall leave it there.
Oh, ask it, Ms.
Oh,
Bishop.
thank you. If I could have inquiry number 000114429 before the screen. This is a document in relation to the lag behind of the UK in its approach to PPE and infection control. And I think in the course of that particular document further down, there is a quote from you about the lack of speed at which we were moving. My question to you not necessarily you need to have particular regard to this, but my question to you is, as late as 2021, your organisation considered that Scotland, as well as the rest of the UK, was significantly lacking behind in its approach to PPE infection control. In your opinion, did the UK ever catch up with the rest of the world, either during the pandemic or after?
In part. But here it's very interesting because this virus has generated extraordinary abilities to change its behaviour as it crosses Hadrian's Wall. The English guidance says that when you enter a room, first of all, it says aerosol transmission is actually rather significant, and when you enter a room with someone with COVID, you should wear respiratory protection, except that the table that footnote is attached to says that you must wear an FRSM for routine care and FFP3 for AGPs. In Scotland, it still refers to respiratory particles in the 5-micron definition, and they've only got the table there, not the footnote, and it says FRSMs for routine care and FFP3s for AGPs. And we understand that the Scottish NIPCM, that's their national manual for IPC, is under review at the moment, and we've seen the prelude to that, and it's still predicated on 5 microns. Have we caught up? I don't think so. Don't know why not.
My lady, I'm obliged.
Thank you very much, Ms Mitchell. That completes the questions the inquiry and the core participants have for you, Dr Jones. Thank you very much for your help.
Thank you.
Mr Scott.
Milady, I don't know whether you wish to rise while we transfer witnesses.
Nope.
I shall move aside for my learner friend.
It's kneeled.
I'd like to call, please, Mr Brunt.
Repeat after me, please. I do solemnly,
I do solemnly,
sincerely and truly
sincerely and truly
declare and affirm
declare and affirm
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
and
and nothing but.
nothing but the truth.
Sorry if we kept you waiting, Mr Brunt.
It's okay, thank you.
Could you give your full name, please, Mr Brunt?
Yes, it's Richard Gregory Brunt.
And Mr Brunt, I think you've given a witness statement to this inquiry dated the 17th of November 2023. That's INQ 000347822. You're familiar with that witness statement? I think you have a copy with you.
I am, yes.
On page 99, that bears your signature and the statement of truth.
Yes, that's correct.
And you can confirm, can you, that the contents of that statement are true to the best of your knowledge and belief?
Yes, it is.
Thank you. Mr Brunt, you're the Director of the Engagement and Policy Division at the Health and Safety Executive, is that right?
That's correct, yes.
And can you explain, please, what does that role entail?
I'm a member of HSE's Executive Committee. The division I'm responsible for leads on HSE's policy issues, engagement with others, communication activities and so on, across the full range of activities that HSE is responsible for.
And in terms of your background with the Health and Safety Executive, you have also worked as a health and safety inspector, is that right?
I have. I've been with the Health and Safety Executive for almost 35 years. I started as an inspector. I've worked across a range of policy, operational strategy and so on. I'm a member of the Institute of Occupational Safety and Health and a Chartered Registered Safety Practitioner.
Thank you. Can you please set out briefly a summary of the role and the function of the Health and Safety Executive, please?
Okay. The Health and Safety Executive is responsible for workplace safety across the range of activities in Britain, from major hazards, manufacturing, agriculture, construction. Our primary focus is on worker safety, the safety in the workplace of people at work. Some of the health and safety responsibilities also are there towards protection of members of the public from industrial risks and hazards that are generated by the work of those businesses.
I think the Health and Safety Executive is also a UK government agency, and it's sponsored by the Department of Work and Pensions. Is that right?
That's correct, yes.
And the Health and Safety Executive was established, I think, by the Health and Safety at Work Act 1974.
That's correct, yes.
And it has a role in enforcing workplace health and safety law. So that's the 1974 law that we've just referred to, and associated regulations. Is that right?
That's right, yes. The Health and Safety at Work Act sets the framework, and there are a wide range of supporting regulations that help enact some of those provisions.
This may seem like a question with an obvious answer, but in terms of those regulations which it falls to the Health and Safety Executive to enforce, do the Health and Safety Executive have a role in making or drafting those regulations?
We do. HSE has its own policy function that drafts regulations. Some of that legislation will have been generated in the past by European legislation, and how we then implement it into UK law. The legislation is retained legislation, so it's not devolved to Scotland and Wales, whereas some of the other legislation that's of relevance in healthcare is a devolved matter. But we are responsible for the interpretation, application of that legislation.
And in terms of when regulations are being drafted, would the Health and Safety Executive have input and advice in terms of the reach of legislation and regulations?
Yeah, I mean, with any legislative drafting, we would be responsible for consulting as to the impact of that legislation through the usual parliamentary processes, with the range of legal advice as to interpretation and applicability of that legislation. So it is all subject to the usual processes of the Parliament. Now,
in summary, what powers does the Health and Safety Executive have in enforcing those regulations in the workplace if they encountered a breach in a particular workplace?
Okay. Short summary, the responsibilities for enforcing health and safety law comes from Section 20 of the Health and Safety at Work Act, and it gives a full range of enforcement ability from provision of information, provision of advice. That can be both verbal and written advice. We have, our inspectors have the power to serve enforcement notices to require improvements where companies and duty holders are in breach of legislation. We have the power to serve prohibition notices for the most serious breaches. And indeed, we have the power to bring legal proceedings and prosecution if that's the appropriate course of action.
So in terms of those, that escalating range of enforcement actions that are open to the Health and Safety Executive, you explained the provision of verbal advice is also regarded by the Health and Safety Executive as enforcement action. Is that right?
Effectively, if an inspector finds a business to be lacking in some respect, the level of action they take is proportionate to the level of breach they've found, and we have ways of working through that. So if somebody is just slightly below the level expected, we may decide verbal advice is sufficient. If it's a little more serious, we would move up to written advice or written action. I think it's relevant when we commit something to writing, the way HSE is funded, that triggers what we call fee for intervention. So a duty holder has to pay to cover HSE's costs for having taken that action. And then as that moves up, enforcement notices and, as I say, ultimately in serious cases, prosecution are all possible. That is the full range of enforcement if an inspector decides they need a business to take corrective action.
Thank you. Now, as to the Health and Safety Executive's approach to enforcement, you've set out in your witness statement that the Health and Safety Executive have designed or developed an enforcement management model to assist inspectors. Could you very briefly, please, explain what that enforcement management model is?
Absolutely. As you pointed out, the Health and Safety at Work Act and those powers came into existence some 50 years ago. And throughout that, the inspector's application of their powers as an individual appointed as an inspector is at the discretion of that inspector and what they found. So historically, HSE, to make sure we are consistent, proportionate, transparent as a regulator, as indeed regulators are required to be, developed a process that captured the thought process an inspector goes through, and we refer to that as our enforcement management model. So it is a tool that replicates a thought process that inspectors go through and still gives them the discretion to make a final decision about enforcement. So very briefly, an inspector visits a premises, they observe the conditions there, they compare them with the expected standards and how far apart the observed conditions are from the standards on site. And if there is a gap, they then assess how big the risk is of that gap, how likely harm is, how serious the harm could be. And all of those factors then play into what we'd refer to as an initial enforcement expectation. So that's the point where we'd say most inspectors would come to this point and say, I think I need to take the following action. We then allow the guidance allows the inspector to take the discretionary local factors as to the conditions they've found on site, previous advice, the attitude of the company, etc., to either escalate that or increase that level of enforcement, or indeed decrease it if they think that's appropriate.
Thank you very much. Now we'll come on to talk about the enforcement management model in relation to COVID-19 in healthcare settings in due course. But you mentioned there that the enforcement management model looks at the level of risk and the level of harm, and there's a categorisation process of different degrees of harm in terms of the consequences of the breach. Is that right?
There is. We categorise from serious harm.
I think there's also significant.
Significant.
Harm.
Thank you. I was just trying to get them in the right order. Serious, significant, minor and negligible.
Thank you.
So there's different levels. And we would compare that against sort of known standards.
But as I say, we'll come back to that in due course, but that's very helpful. You also set out that under the Health and Safety at Work Act, there's a general duty for every employer to ensure, so far as is reasonably practicable, the health, safety and welfare at work of all its employees. And that general duty extends to those employers working within the healthcare setting to look after the health, safety and welfare of its healthcare staff. Now, in healthcare settings, not all those workers who are going to be working in that setting are directly employed. They're not all employees. Some might be agency workers, some might be contractors. In terms of protection of the health and safety of those workers who are not employees, does the Health and Safety Executive have a different approach to those, or do the duties also extend to them?
No, those duties extend. The framework of the Health and Safety at Work Act is goal setting. It requires those people that create the risk to manage the risk. And it recognises within the Section 2 refers to employees, Section 3 refers to others who may be affected. And we take that as those that are working under an undertaking, be it a business, be it a health trust, a duty holder. That duty extends to protect all of those that are affected by that work activity.
I think Section 3 also is considered to extend to risk to patients who would be in a health healthcare setting. But you go on and explain that there is a memorandum of understanding between the healthcare regulators and the Health and Safety Executive in terms of how their respective responsibilities are delineated in that regard. Is that correct?
That's correct. As I said, some of the healthcare matters are devolved to the nations of the UK, whereas health and safety legislation is retained. Because of that, there are slight differences between England, Scotland and Wales, and I think clarify that HSE works in GB, and there is an HSE Northern Ireland that takes care of the Northern Ireland. So we have the arrangements between those healthcare enforcement bodies. Their primary focus is generally on patient safety in terms of clinical decisions, treatment, etc. Some of the health and safety of patients is also devolved to those other bodies such as the CQC in England and the equivalents in Scotland.
So that would be non-clinical risks such as slipping, scalding?
Absolutely, the non-clinical. The clinical rest with those agencies.
So the focus of the Health and Safety Executive, of course, is on workplace health and safety. And you've explained that in relation to healthcare settings during the COVID-19 pandemic, that remained your focus. You did not have a role as the enforcement body for the coronavirus regulations in the workplace or in healthcare settings. Is that right?
That's correct. The coronavirus regulations were made in recognition that the Health and Safety at Work Act itself is work-focused and not focused on the more general public health issues of a pandemic. So the coronavirus regulations were made to address some of those difficulties where we would not be able to apply the Health and Safety at Work Act.
And you explained that the enforcing role was with the police and local authorities in relation to the Coronavirus Act. Is that right?
That's correct, yes.
If I can move on to those regulations that were enforceable in healthcare settings during the pandemic by the Health and Safety Executive, we're going to look at the control of substances hazardous to health regulations, which I'm going to call COSHH, and the reporting of injuries, diseases and dangerous occurrences regulations 2013, which I'm going to call RIDDOR. But if we can deal firstly with COSHH. You've explained in your witness statement that COSHH applies to both incidental exposure to and deliberate work with biological agents. Excuse me, is that correct?
That's correct, yes.
And you go on to say that that would not apply to the situation where one employee catches a respiratory infection from another employee. Is that right?
That's correct.
Can you explain how the COSHH regulations applied to COVID-19 infections in a healthcare setting during the pandemic?
I can, but I think just to set the context, it would be useful to explain that COSHH, like a lot of other legislation, requires a risk assessment process and a hierarchy of control. And that hierarchy starts with eliminating a hazard. If you can't eliminate it, you substitute. If you can't, you use physical controls, you use administrative controls, and ultimately, if you can't do all of that, you may rely on personal protective equipment. And that does have to be applied as a hierarchy, and it does have to be applied on the basis of a risk assessment. So in a healthcare setting in relation to COVID, in some of those non-clinical areas where you were thinking that there may be people that could coincidentally come near patients with COVID, such as cleaners, you would be looking at the elimination, the distancing, physical separation, and so on. As you start working through that, you recognise that some of that hierarchy cannot be applied and still enable a healthcare worker to give the right level of care to the patient and carry out any procedures and care they may need to give. So in those, you get closer and closer to relying on personal protective equipment. All of that does have to be based on a risk assessment that is applicable to that undertaking. But some of the standards expected could be extrapolated from elsewhere.
All right. We'll come on to that in a moment. Does COSHH specify precisely what level and types of PPE should be provided to workers, or does that depend on a risk assessment?
That depends on the risk assessment. COSHH is applicable to a full range of work activities right across all industries, and because of that, as I said, it sets the goals and the process by which you must get there and leaves the decision making to those that have the most knowledge of the risk and the ability to control it.
Now, you said a moment ago that it may be possible for employers to extrapolate what's the appropriate protection from other sources. I don't think we need to get this up on screen, but from health and safety guidance that was drafted to guide decision making by health and safety executive regulatory staff, it says if an employer is following the relevant public health guidance for their sector, they will generally be taking reasonably practicable precautions to control workplace risks. Now, in relation to the UK-wide IPC guidance, I think you refer to it sometimes in your witness statement as the Four Nations PHE guidance. That's the same thing.
That's correct. It's the same thing, yes.
So if an employer in a healthcare setting during the pandemic ensured that the UK IPC guidance was being implemented and the PPE specified in that guidance for that activity was being provided for workers, would the health and safety executive consider that that employer had taken appropriate measures to protect workers from risks of COVID?
The simple answer is yes, and I think to explain that and put it in context, you've used the phrase quite rightly, reasonable practicability, which is the bedrock of the Health and Safety at Work Act. That is a balance between the level of risk and the amount of effort to manage and control that risk. And that's where a judgment comes in. If I then refer it to the enforcement management model that we've talked about, we would look for benchmark standards as that measure of reasonable practicability. So effectively, the IPC guidance and the parts of that relate to protecting the healthcare worker would be seen as a defined standard that demonstrates that that level is being achieved.
Did the health and safety executive consider that there was a lack of clarity for employers concerning their duties under COSHH and how they might apply the IPC guidance?
I think we've looked at that as through our work and how we have supported and helped healthcare trusts throughout the pandemic. As I said, some of the approach we use is about to enforcing and ensuring compliance with duty holders is around providing adequate information, etc. So effectively, our advice and support to trusts through the various routes we'd have used would have indicated that using that guidance is the right thing to do and given them that latitude to look at their local risk assessment required by that the employer could carry out to actually decide whether or not that fully fitted their situation. I think the other thing is that IPC guidance will have set a sort of the benchmark, the minimum standard to be achieved. Should someone wish to go above that, there would be nothing to stop their assessment saying that's what they could do.
Thank you. But certainly, if a healthcare employer didn't go beyond that minimum standard or minimum level of protection specified in the IPC guidance, the health and safety executive wouldn't consider that to be.
We accepted that as the appropriate level of compliance.
Can we have a look, please, at the PPE ensemble table under the IPC guidance? This is INQ 000269663. Have you got that on your screen?
I have, yes.
I think you explain in your witness statement that in March of 2020, the Health and Safety Executive were invited to comment on these PP ensemble tables in relation to the UK IPC guidance. This had been formulated by the UK IPC cell. Did the Health and Safety, other than being asked to comment upon this table, did the Health and Safety Executive have any role within the UK IPC cell? Were they members of that cell? Were they involved in formulating the guidance?
We would have provided advice in the same way as we've commented on this, so our regulatory and scientific advice through the Department of Health, through Public Health England at the time, and sort of acting as an advisor in our sort of role as a Category 2 responder for UK emergencies.
If we can have a look briefly at some of the PPE that's set out here as recommended. We can see that in the third row, working in an inpatient area, not a higher risk acute care area, with suspected or confirmed cases and frequent direct patient contact within 1 metre, what's recommended there are single-use disposable gloves, single-use plastic apron, sessional use fluid-resistant, it says type 2R surgical mask, and sessional use eye protection. And then if we can have a look at the top row, please, performing an aerosol generating procedure in any setting. What's then recommended is single-use disposable gloves, single-use disposable fluid-resistant gown, filtering face piece respirator, single-use, and single-use eye protection. Did the Health and Safety Executive have any role in specifying or have a position on airborne exposure to COVID-19 in relation to non-aerosol generating procedures?
I believe at that time the scientific advice and our chief scientific advisor will have been part of the national bodies sharing such information, that at the time this was drafted, it was considered that airborne aerosol transmission wasn't a factor other than those aerosol generating procedures. So we will have challenged the science behind this and made sure that we were satisfied as a regulator that that was the best available information at the time.
All right. If we can look at the different types of PPE, we see that filtering face piece respirator is specified for aerosol generating procedures. I think you've explained in your witness statement that the filtering face piece respirators for use in healthcare settings in the UK are FFP3 and FFP2. Is that right?
That's right.
And that FFP2 have been found to be equivalent to the US specification N95.
That's correct.
And you've explained in your witness statement that whilst FFP3 was the usual recommended control measure, if global supplies of FFP3 masks were low, FFP2 could be used as an alternative.
That's correct. So effectively, the number at the end of FFP is equates to a level of protection, and effectively how much of a contaminant you could be exposed to and it would protect you from and for how long. So FFP3 gives a higher standard. As I recalled, when changes in the sort of World Health Organization position changed as to how big a risk this was, there was a move to say FFP2 was sufficient for the level of risk and how communicable the disease was.
Thank you. If we could look now, please, at fluid-resistant surgical masks. I'm going to call these FRSMs. They are not considered by the Health and Safety Executive to be PPE, are they? You say in your witness statement they're used to source control. This means they're intended to limit the transmission of infective agents from staff, the wearer, to patients, the non-wearer, during surgical procedures and in other medical settings. The aim of universal masking in hospital settings using surgical masks was to reduce the emission of virus particles by everyone wearing a surgical mask. Does that mean that the Health and Safety Executive consider that fluid-resistant masks offer no protection to the wearers?
They offer a limited amount of protection for droplets, and I say limited in terms of they're not the same as an FFP. If put it in context, HSE regulates the provision of PPE. PPE is designed to protect the individual and nobody else. It's personal. The fluid-resistant mask is classed as a medical device, not as PPE. It's regulated by the MHRA, that's the Medicines and Healthcare Products Regulatory Agency, and we obviously liaise very closely with them around those. So although it may offer some protection, it's not what we would consider PPE. You may look at it in terms of being other parts of a precaution.
When the Health and Safety Executive commented on this ensemble table, PPE ensemble table, did the Health and Safety Executive raise any comments about the adequacy of specifying fluid-resistant surgical masks in non-aerosol generating procedures?
I think from our point of view, I don't know categorically whether or not we did offer any comments on that, but we would be looking at that. We would be looking at the aerosol generating procedures as the things that are likely to affect the worker, which is where we would have a focus, rather than necessarily on the outside of that environment, and that would be for the MHRA.
Did you raise any issues with, this is set out as a recommended PPE table, but fluid-resistant surgical masks are not considered by HSE to be PPE? Was that point raised in the drafts on the guidance?
As far as I'm aware, yes, it would, and certainly I know the conversations that I had with PHE and DHSC throughout the pandemic, we were always going back to that fluid-resistant masks are not PPE.
Thank you. While we're on the subject of PPE, and we can take that table down, thank you, Lawrence. I'd like to deal briefly, if I can, with some issues that arose during the pandemic in relation to marking on PPE products. And there were broadly three areas of concern, and we can go through each one. But firstly, PPE that was not CE marked as compliant with conformity with European safety regulations. Secondly, PPE that had been relifed by placing a new expiry date over the original expiry date stamp. And thirdly, PPE that was marked not for medical use but was used in healthcare settings. Is it right to summarise it in this way? In respect of all three of those labelling issues, before that any such PPE was made available for use in the healthcare sector, that PPE had to have been assessed by the Health and Safety Executive and found to be compliant with the relevant elements of the essential health and safety requirements of the regulations.
That is, and I'd also stress that it could only be supplied for the healthcare sector because HSE were able to give that derogation under EU legislation. We were a member of the EU at the time. And that would not allow that equipment to be used anywhere outside the healthcare setting.
Was the Health and Safety Executive aware, or was it made aware during the pandemic, that those three types of RP, or those three labelling issues, were causing concern for healthcare workers in healthcare settings, as to causing some confusion about whether those were appropriate items for them to use?
Yes, we were aware of that. We worked very closely with DHSC and others through the supply chain gave advice as to the information that would also need to be included in those. As I said, the whole basis of being able to provide that for healthcare was the derogation that was from EU legislation that said for healthcare only, the enforcing authority can, subject to them being satisfied with the performance of that equipment, allow it to be supplied in these circumstances.
And so was it envisaged by the Health and Safety Executive that it would be for employers to explain that those safety steps had been taken?
It would be ultimately for the employer to explain. The expectation is it's cascaded through that supply chain, which was being run very closely by DHSC and others, saying make sure adequate information was being provided with that PPE to be able to explain those circumstances.
Thank you. If we can move on, please, to fit testing of respiratory protective equipment. You explained that in relation to FFP2 and FFP3, those are respirators which rely on having a good seal, a good fit and a good seal with the skin of the wearer. Is that right?
Absolutely. In order to give the right level of protection, they've got to fit very firmly against the face, because if there's any gaps, as you inhale, the air takes the line of least resistance, and it can be as significant as a gentleman that hasn't shaved for 24 hours. The mask worked yesterday, it might not work today.
And you explain that there are two basic types of fit testing, qualitative and quantitative. Am I right to summarise it in this way? Qualitative fit testing relies on the subjective assessment of the wearer. They're asked to apply the mask, and then a strong smell or a bitter taste is released, and it's a question of whether they can smell or taste that substance that's being released. Is that right?
That's correct. I mean, very broadly, there's two ways. One, you either put a measuring device inside the mask and see what is being drawn into the air, quantitative measurement. Otherwise, it's asking someone, is this fitting? Can you smell or taste whatever's being exposed to?
And with a quantitative measurement, there's a machine that has to do that.
There is, yes.
And with either type of fit testing, the fit tester has to be trained to carry out a fit test. So that requires training of personnel.
Yeah, you need a person with the right skills, experience, etc. Trained, yes.
And evidently, as everyone's face shape is a different shape and size, it's going to be unlikely for a single model of FFP to fit every face type. So it's necessary to have a range of models, is that right?
Exactly. Any employer, anyone that's relying on PPE should have a number of different models. You then test to see which one is giving the right level of protection.
Now, you've been made aware, I think, of a study which has been provided. It's been provided to the inquiry by the Federation of Ethnic Minority Healthcare Organisations, and that's been provided to you. And that study found that the failure rates of fit testing were significantly higher in staff from black and minority ethnic backgrounds. Was Health and Safety Executive aware that fit testing was more often failed by black and minority ethnic staff?
I think some of that information was available. The key point to us is that somebody has to be able to pass a fit test before you're relying on that protective equipment, and hence underlines the importance of having that range of models. Effectively, the standards that PPE is designed to, certainly that is CE marked, is based on European standards and the face shape of those ethnic groups.
Did the Health and Safety Executive take any steps in relation to those difficulties with not every model fitting every face? Did Health and Safety Executive issue any guidance or any advice for employers about the need to have a diverse range of
Yes, our guidance has always said that, and that would have been the guidance we relied on. As I said, it is the individual nature of PPE.
Now, you set out that there were a number of issues with fit testing during the pandemic. A lack of testing machines, sometimes a lack of the testing fluids that were needed for qualitative testing, and also issues in relation to staffing resources to carry out the fit tests. And you explained that towards the end of March 2020, Chief Executive for a group of NHS trusts contacted the Health and Safety Executive to ask whether it would be possible to remove the requirement to fit test RPE and do a fit check instead. Can you help us with the response of the Health and Safety Executive to that request?
If I summarise it, it was
Yes.
You must do a fit test. A fit check is not a substitute.
What is a fit check?
A fit check is sort of like the daily check by the person using the PPE to assure themselves that they have fitted it correctly as it was at the fit test. A very simple way of describing it is having had chosen a model that gives you the right level of protection as part of the fit test. When you then put it on, you put your hands over the filter to sort of try and slow the air going down through it. Take a sharp intake of breath and see if it collapses. In very simple terms, it is just making sure it's on as it is supposed to be.
Thank you. What would the Health and Safety Executive view be of any proposals to, in a future pandemic, to amend the regulations so that there could be a derogation from that requirement to fit test if resources were scarce, if there was a lack of fit testing staff or equipment?
And it would be the same response as this pandemic. You have to fit test. The adage that we were living by was personal protective equipment has to protect. And anything that undermines that, you're not satisfying your legal duty.
Now, if either a member of staff failed the fit tests for the models of RP that were available, or there were some other reasons, religious head coverings or glasses or beards that meant they couldn't get a good fit, were there alternatives that offered a similar level of protection?
There are. I mean, FFP, filtering face piece, the mask as we commonly refer to them, they're not always popular, they're not comfortable, etc. There are other respiratory protective devices that involve filtering air and pumping it through a mask or a hood. We'd call them positive powered respirators, so they blow air in and create a sort of cushion of air around your face. They'll tend to be, as I say, a hood type or something of that nature.
And were those specified? We didn't see those specified in the ensemble table that we saw. Were those specified in IPC guidance, those alternatives to RP2?
I can't off the top of my head recall if they were specified in IPC guidance, but certainly within sort of health and safety standards and guidance on PPE, they would have been there as an alternative.
Thank you. Can we move on, please, to reporting of injuries, diseases and dangerous occurrences regulations, which you'll be relieved to know I'm just going to call RIDDOR.
Thank you.
You set out the outline and purpose of RIDDOR in your witness statement, and you explain that these regulations provide the national reporting framework for responsible persons, that usually means employers in healthcare settings, to report certain cases of injury, diseases and specified dangerous occurrences to the relevant enforcing authority, which in the case of healthcare settings is the Health and Safety Executive. The purpose of those regulations is to inform HSE in a timely fashion that an incident or event has occurred, and it allows an appropriate regulatory response to be made. It's not a source of definitive statistics as to reportable workplace incidents, but it does enable the broader monitoring and analysis of trends over time and prioritisation and targeting of risks in particular sectors. Is that a fair summary?
That's how we would use that data. It either enables us to make an immediate response where something very significant has happened and we believe there may be unmanaged or uncontrolled risk, but also that sort of overview of particular industries that helps us with targeting of our resource.
And you also set out that making a report under RIDDOR is not an acceptance of blame or that a breach has occurred.
Absolutely, it's just a statement that an event has taken place.
And you have stated that RIDDOR was not intended to be used in a pandemic involving thousands of instances of infection. It was really designed to capture single one-off unexpected events, accidents and incidents. Is that right?
I think it's a very fair way of viewing it. That's the intention of those regulations as to what is happening in a workplace, not what is happening globally or across the country.
And in terms of reporting COVID-19 under RIDDOR, I think the Health and Safety Executive published guidance. I think the first guidance was on the 2nd of April 2020, and that set out that the responsible person, so the employer, was required to make a RIDDOR report if there was reasonable evidence that a worker diagnosed with COVID-19 had been exposed while at work.
That's correct. I mean, I think that it's useful to have the context that the injuries part of RIDDOR has very specified injuries, and it lists what those are. The diseases part of RIDDOR has specified diseases, it lists what those are. Neither of those apply to COVID. The dangerous occurrences is the exposure to a biological agent, so it's very broad, but that's why it needs that reasonable evidence that is linked to work to actually fall under that duty to report it.
How would that apply to healthcare work? Wouldn't it apply to all of them? Because, yes, they may catch COVID on the bus or in a cab to work, but chances are the exposure was at work. How does it not mean that every case of a healthcare worker getting COVID would have to be reported?
We're looking at we were taking the view it's the work activity. So if you're exposed to a colleague at work that, you meet them coincidentally in the corridor, etc., that's not the work activity. So we were looking specifically at those people that could be exposed to patients known to have COVID, carrying out procedures where they are sort of directly interacting with them. And it requires a judgment by the employer. The duty, the legal responsibility is with them to decide how likely it was that it was caused by that work-related exposure, working with patients. And it's not necessarily... We also need to think about this in terms of RIDDOR applying across all businesses, and we're trying to be transparent and consistent, and it's the same, whereas just because I was in the same workplace as somebody that had COVID doesn't necessarily mean I did catch it from them. There is a judgment as to how did my work bring them into contact with that disease.
I go back to the point I make. Every healthcare worker in the front line had hugely increased exposure. So if they got COVID, the chances were it was work-related. So wouldn't you, under this guidance, have been inundated by trusts saying this number of doctors, this number of nurses have all got COVID, and they couldn't tell you whether they got it in the corridor when they were passing a colleague or whether they got it when they were dealing with a patient.
Or on the bus or at home.
Yeah.
And that's why it requires an employer to actually be looking at what's going on. It's a difficult judgment. It's legislation that wasn't intended for this type of situation, and we had to work out what do we do that gives us a reasonable view of what's happening in workplaces and indeed what we may need to do in response to it. It is not intended to track the total number of cases that are happening. It's not intended necessarily for that liability. And if it's helpful, we could talk about the purpose of investigation and selecting them for investigation.
I think, following on from your ladyship's point, can I ask you, Mr. Brunt? You say it became quite clear to the Health and Safety Executive early in the pandemic that there was both over-reporting, or what you determined to be over-reporting and under-reporting of COVID-19 under RIDDOR. And you explained that when the guidance was first published, the Health and Safety Executive received a large volume of queries from employers, picking up on just the point that the lady made, clarification as to what constitutes reasonable evidence that the worker was exposed to COVID-19 at work. Is that right?
That's right, and we did several iterations of that guidance in a relatively short space of time for exactly that reason. The feedback we were getting, as my lady said, was people were struggling to understand how to apply it, when to apply it.
And can I ask this, after several reiterations or iterations of that guidance, were you still getting a large number of queries, or did the guidance have the desired effect?
It had some effect, and we still needed to write to individual trusts collectively to explain what we expected of them and to help them improve the overall figures. And this has always been a feature of RIDDOR. There are some areas you get under-reporting, some areas you get over-reporting. It is not unique to this situation.
Can I ask, from the health and safety executives, what are the consequences of under-reporting under RIDDOR? What would the practical impacts of that be?
If we were looking at an individual business, then you don't have a picture of what's happening there. In the circumstances with COVID and reporting, we were still able to extrapolate enough of that to be able to understand how people were applying precautions in the workplace and to be able to take a sort of holistic approach to helping those healthcare settings in terms of how they comply, how they improve their procedures. And indeed, some of our inspection activity in hospitals and healthcare trusts was geared up exactly for that, to be able to assess what was going on, identify where the best practice were and where the shortcomings were, and again go to the whole industry and be able to share that information to enable improvement.
You've been provided with the witness statements of 4 of the core participants in this module: the Trades Union Congress, the Royal College of Nursing, the British Medical Association, and the COVID-19 Airborne Transmission Alliance. And all those core participants have taken the view that the Health and Safety Executive set the bar too high for reporting occupational COVID-19 in healthcare settings under RIDDOR. What's the health and safety view on that?
We think that that bar was the correct one. We kept that under review. It was peer reviewed over a period of time by senior regulatory colleagues as to was that giving us the appropriate information. From having looked at the statements that you've mentioned, I think you have to consider the angle of what the expectation is. If it is an expectation that everything gets investigated and there's some incredible retribution for what happened, that isn't the purpose of necessarily selecting incidents and investigating them. So when we investigate an incident, it's either to improve our knowledge on an emerging situation, or indeed, part of that is to consider whether or not there is corrective action or punitive action. When we looked at the incidents that had been reported and our selection of those that were reported, there was a proportion selected for investigation. There's many we looked at that decided we couldn't see the causal work link and did not investigate. Some of those, we have a threshold of incident selection criteria that's long established and published as to what we will investigate and won't. A lot of those COVID cases will have fallen beneath that bar. And then of those we did select, we go on to decide, is the new learning that we feed back into the system where we've identified new problems, or is this down to individual businesses, is individual settings not actually applying the guidance in the right way and being able to improve that?
Given the numbers we're dealing with, so it's going to be very unlikely you're going to be able to investigate individual cases. Wouldn't one solution have been to say, right, all National Health Trusts, hospitals, whatever, have to report every member of staff or contracted worker who gets COVID, And then you, as a health and safety executive, can analyse whether there appears to be a systemic problem. In other words, is that hospital properly carrying out infection prevention control measures? Are they providing the right PPE? Isn't that the only way you can cope with an analysis of the workplace safety in a pandemic, when you've got so many hundreds and thousands of healthcare workers and contractors who are falling ill with COVID? Haven't you got to move from the individual case to the systemic case?
To the systemic case, there's many ways that we can regulate, and what we did during the pandemic, as well as looking at whether we investigate particular incidents or patterns. We carried on with inspection activity in hospitals where we were looking specifically at COVID controls, or we did inspections and also looked at COVID controls. As a regulator, you don't have to visit every business to regulate them. You need to learn enough to be able to tell those businesses what to do. And that doesn't matter whether it's healthcare or anything else. So a proportionate and transparent approach to it. And indeed, that's what we did. Our inspection activities that continued on hospitals, we extrapolated information from that to be able to help those healthcare settings across the piece be able to identify where the challenges were, the sort of things that we would find. So there is a level as to at what point will you stop learning anything new and be able to say that, we understand enough to tell them what is expected.
So does it follow from that, Mr. Brunt, that what you're saying is RIDDOR isn't used to track general compliance with health and safety rules in a workplace? It has a different purpose than the way you try to track compliance in a workplace or across a sector is through your inspection activity?
There's a whole range, and I could spend far too long talking about it, but in terms of targeting activity, RIDDOR is part of a data set. We also pick up data from what concerns we may get reported to us. There are labour force surveys that look more generically at what's happening across businesses. So that is how we function as a health and safety regulator. In these particular circumstances, say we understood, we knew what we were getting was going to be varied trust by trust, but collectively putting that together with intervention data, etc., gave us an approach to be able to play our part in the workplace regulation that was part of a bigger UK-wide management of a pandemic.
Can we move on, please, to deal with inspections and spot checks in healthcare settings during the pandemic? I think you explain in your witness statement that the Health and Safety Executive didn't continue to undertake inspections in healthcare settings. There wasn't a formal suspension of inspections, but operational decisions were taken to initially cut back on inspections when the sector was under strain. And you explain that between, as part of your inspection activity, between December 2020 and January 2021, there were inspections focused on COVID-19 arrangements at 17 acute hospitals. That's 13 trusts in England, 2 health boards in Scotland and 2 in Wales. And in terms of the outcomes of those inspections, I think it's right to say that the Health and Safety Executive identified that there was quite a wide range of compliance, both with the health and safety rules, both in terms of comparing the hospitals with one another, but even within hospitals. And you noted particularly that there were lower levels of compliance frequently found in non-clinical areas, even where those were adjacent to clinical areas. Is that a correct?
That's correct. That's a good summary.
If I can ask now, please, about COVID-19 spot checks. I think these were just introduced during the pandemic to try to check how businesses generally, not just healthcare settings, were implementing the COVID secure guidance about keeping workplaces COVID secure. But healthcare settings were amongst the workplaces that were subject to spot checks. Is that right?
That's correct.
And if we can briefly summarise in numbers, the spot check programme, 483 spot checks and spot inspections were conducted in healthcare settings, and from those 483, 18 duty holders were issued with written advice. Do you consider that that's quite a low enforcement rate?
I think that's proportionate to what we were finding. So the enforcement rate depends on the fact that what you find when you carry out an inspection. But the spot checks, to clarify that, not all of those are necessarily inspections by regulatory inspectors that carry warrants. There was a process there by which effectively the spot check gave a 3-stage triage process. So the initial check, contact, could be by phone, it could be by a non-warranted person visiting. That enables you to assess whether or not you believe someone's compliant. If there was concerns, that moved up to a second stage. If that still didn't give a satisfactory answer, that moved over to a regulatory inspector, a warrant holder, who could take enforcement action if necessary.
In terms of the process of the spot check, I think the first stage was a questionnaire that was completed by the duty holder, is that right?
That's right.
And then the second stage could be a visit or it could be carried out by telephone.
That's right.
So those features of the spot check put quite a strong reliance and a trust in the answers of the duty holder being accurate and honest. Would you agree?
Well, in as much as that we then go and validate whether or not we're getting the right answers and whether what we're being told is what's happening. So we had a good validation process behind that involved sample inspections and follow-up. And I think we were finding, as I recall, 96% compliance with what we'd been told over the telephone. So we validated that we could be confident what we were being told was right. I mean, if we look at spot checks across the piece, the country is facing something it's never faced before. On the whole, everybody's saying, tell us what you need us to do and we'll do it. And that was the guidance that was going out across businesses that was produced for the safer workplaces. That is as applicable to healthcare settings as everywhere else. So generally, a spot check call puts people on notice that you're looking. And those that want to comply will do everything they can to comply. It helps that we're really gauging their understanding of what they're putting in place.
Thank you. Now, you mentioned earlier that as well as inspections, there's a process by which the Health and Safety Executive are able to receive and monitor concerns that have been brought to the attention of the Executive by workers or indeed members of the public. And I think you explained that those concerns can be reported to the Health and Safety Executive via the website or by a telephone. And in spring of 2020, I think the Health and Safety Executive were aware that there was a greatly increased level of concerns coming from healthcare settings, and particularly regarding the availability of PPE and the inadequacy of fit testing for FFP3 face masks. Is that correct?
That's correct.
And you've set out some of the data around health and safety concerns logged by the Health and Safety Executive in relation to COVID-19 in healthcare settings. This is from the 1st of March 2020 to the 30th of June 2022. So that's the relevant period, or roughly the relevant period of this module. And there were 1,587 such concerns logged. 192 of those were categorised under the red, amber, green system as red concerns. Would a red concern trigger an inspection of a setting?
That's right. Effectively, a triage system to decide the credibility, validity, the seriousness of what we're being told and how to intervene with that. So the red concerns, those that we see as the most serious, that would trigger a visit. Those of that we would consider to be amber would trigger a contact, but not necessarily in person. It's a telephone, for example.
And in terms of how these concerns could be reported to the Health and Safety Executive, was it possible for workers to report a concern anonymously?
Yes. That's always been a feature of our concerns process, that people can contact us, raise their concerns about their workplace, and as far as we can, give that anonymity, particularly if they're doing it online.
And in terms of those workers who may have precarious employment situations, and particularly those who aren't union members or who are maybe not employees, did the Health and Safety Executive take any steps to ensure that the system for reporting concerns was accessible to all healthcare workers, including those that I've mentioned?
Yes, the telephone and web facilities are available for anyone to use.
Was there any sort of outreach work done by the Health and Safety Executive to bring to people's attention that there was this process for reporting?
I can't honestly answer that one. I don't know the answer.
Right.
If it's something in my statement I may have forgotten.
If we could turn now to look at the health and safety approach to enforcement action during the COVID-19 pandemic and the way that the Health and Safety Executive applied the enforcement management model, which you mentioned earlier. You've explained that as part of that management model, there's a categorisation of the risk of harm. And in terms of COVID-19, the health effect was categorised as significant rather than serious. And it may help you if I remind you from your witness statement how the Health and Safety Executive defines serious harm, and that is harm that has an effect which is permanent, progressive or irreversible, permanently disabling, a lifelong restriction of work capability, or a major reduction in the quality of life. And significant harm, which is one rung below, is non-permanent or reversible, non-progressive, and any disability is temporary. Is that right?
That's correct. It's looking at what is the likely outcome of the exposure to the risk and the harm that eventualises from that risk.
And I think in terms of that classification, although it caused some controversy at the time, the Health and Safety Executive peer-reviewed that classification and it was confirmed. Is that correct?
Absolutely. And when we are looking at that sort of level, it is what is the most credible, what's the most likely outcome of that risk to the working population. So taking into account in the circumstances of COVID, the scientific advice, the medical advice, etc., of what is most likely for somebody that contracts COVID in terms of the long-term outcome.
And that's in terms of the working population as a whole, so that the risk isn't, or the effects aren't stratified. For example, if it was a 65-year-old worker who might be more likely to suffer.
It's the working population on average, yes.
Thank you. And so that probably answers the next question, but one of the points that was made was in relation to long COVID having potentially long-term disabling effects, and whether knowledge and understanding about long COVID developing in some people who had contracted COVID, whether that would affect the classification of COVID-19 as significant rather than serious.
Right, and as with everything else during the pandemic, as evidence came out, we did keep that under review. And again, when we reviewed that, and including our sort of scientific and medical advice, that peer review said that's still the right classification when we're comparing that with all the other risks that HSE is responsible for regulating.
And as a final point on that topic, you've said that the decision to classify the health effect of COVID-19 as significant did not impact on the level of enforcement action that an inspector could take in respect of a COVID-related matter or breach. Is that correct?
That's correct. As I explained earlier with the enforcement management model, it sets an initial starting point for an inspector to consider what enforcement action is relevant. And you have to consider that enforcement action is relation to the severity of the breach of legislation and not what the actual outcome may have been, because, if I was to try and put this in very simple terms, anyone can slip over and receive a really minor injury on a perfectly level floor. Equally, you can fall over and bang your head and suffer a really major injury. The severity of the incident, the causal effects is the same, and that's where we'd be pitching what the enforcement outcomes are. And that's not necessarily the same as the physical outcomes of the consequences.
Mr Brunt, thank you very much. I wonder, my lady, if that's...
Yes, certainly. I hope you were warned that we'd be breaking for lunch, so we wouldn't...
I was indeed, thank you.
Thank you. I shall return at 1:45.